When I have to write on or speak about animal legal personhood or intersections between animals and law, I always wonder what has been left to say. It fascinated us so much in the last few decades that a commendable number of good scholars have immersed the subject with ideas, philosophies, and assemblages from several disciplines. However, it also leaves me wondering about things that remain unsaid, something so pertinent and bewildering, reflective of a boundlessness and fluidity that characterizes both the life and the law. The question of animal legal personhood is more about holding up the mirror for reflections on law than about finding spaces where the animal question can fit into the range of questions that law always seeks to answer. It is a series of self-reflections on what law is and what law ought to be than what law can do. When I first thought of working in this area as a novice taking a break after my BCL exams, I was convinced that this was all going to be about justice and how best we can secure the interest of animals by a polished strategic litigation that effectively evades moral and ethical conundrums for its own good. Over the years, it was not difficult to wake up to the reality that courtrooms were interesting spaces for the intersection of species politics with legal identities of species, neither of which had any overwhelming deterministic role in the animal legal personhood question. Even recently, as I set out about writing this abstract for the paper, I thought the work would be more about performative character of law and legal actors, looking at how juridical spaces demand definition and organization of subjects before them. Frankly, my doctoral work, which deals more with indigenous environmental justice, steered it in a direction that I had fully seen to be open. So when we say animal legal personhood and multi-species justice, we are proceeding into a territory where no legal definitions are available. It is as uninhabited as it seems unlikely and uncharted. I called it a work in progress, for the more I read the paper, I was unsure whether I had really made any point towards arguing the juridical space as an actual space of inscription. From the instances I had chosen to illustrate my point, these felt more in the nature of evidence towards the fact that if indeed you push towards recognizing non-human life forms, there would be a staunch opposition from formal legal structures and courts, and judges would simply helplessly throw up their hands, demonstrating their inability to recognize either the subject or its suffering. Clearly, this emanates from the fact that the process of litigation has done the job of inscribing the animal in ways it fits well as a legal subject and anthropomorphize its suffering so that it is recognizable for the court to grant whatever relief is being sought. In reality, the process and ramifications of a choice of actions remain more important than success of litigation. So, how exactly can one deal with the complexities of animal legal personhood? By venturing to grant a greater import to the idea of animal agency with little consideration for how willing and prepared the legal apparatuses are? Or is it about effectively performing before the law in order to ensure an effective remedy, even if it falls short of actual granting of the legal personhood? Animals have always been the subject, not in their own standing though. E.P. Vaughan's work effectively demonstrates that, and for those of you who haven't read that stellar work, you should do it, for the hilarity of seeing animals as fully competent to stand trial and bear rights of an ordinary human is phenomenal and important. But there have also been instances of soft law recognizing more than juridical rights, such as the 1989 CITES Convention, which spoke about moral rights of elephants thanks to the efforts of activists like Ian Douglas Hamilton. But the instances have always been few and far between, never consistent, and mostly limited to what Greg Mittman calls media chick species, just like animal legal personhood litigation that keeps returning to great apes. And then after all these interesting developments since the period Evans wrote about, all of a sudden the animal becomes unfamiliar. As we have all seen, they begin come before law as properties, as entities to be protected from cruelty, a limited extent of cruelty that's visible and that needs to be regulated. You can recall two powerful references here. One is Haraway's Contact Zones, where she argues that the symmetric power relations can be beneficial when the interlocking of practices and systems could act towards beneficial co-constitution of parties. So if courts are indeed a contact zone for animals and law, what had come of it? The question is not only have we achieved anything in the nature of becoming with, but also can we achieve it? There is a powerful countervailing force that Kafka refers to, before the law, and also must pay homage to Carrie Wolf's work here, that fascinating title that never seems to lose its steam, reminds us of Kafka's Before the Law reminds us of a man from the countryside waiting futilely before a gate that never seems to open, but that was always meant for him. Similarly, animals wait at the doors here of justice, not merely of law. While law may have been designed for an exclusive human community, justice was never meant to be so. But we and our constructs and institutions operate as insatiable gatekeepers to keep them away. Which also brings us to what Sutonarts and Kimilika calls the political impasse. It's not just political, but also legal in deciding on legal personhood, for we can never reconcile ourselves to the fact, and to quote them, despite the efforts of moral philosophers and opponents of animal use and killing, we remain confronted by a political impasse with little evidence of structural reform capable of fundamentally changing our pattern of human exploitation and violence towards animals. Which is where Dinesh Vadivel's work also usefully speaks about transformations, not just addressing few complexities in the problem, but the whole scheme of things that need to be dismantled. The second thing I've tried to elaborate in my paper is the element of unfamiliar suffering as opposed to unfamiliar subject. That poem was from Colin Dion's wonderful book, With Dogs at the Edge of Life. I've just presented it here for you and for the courts to think about all the heavy-duty words that keep going around. Sentience, rationality. Sometimes suffering is simple. The only reason that it can go unrecognized is because of our collective unwillingness to recognize it. That is the case with most animal rights litigation. The fear of opening a can of worms, not of animals walking into courts seeking to be recognized, but the very fact that we will have to confront our moral positions about living, killing, and letting live, the word of Povinelli. Are courts the only spaces governing and defining animal bodies? Of course not. There have been a wealth of important literature on carceral spaces, killing fields, slaughterhouses, regulated killings. For me, these three are very important work, the stellar examples of violence that law is capable of. And often, especially with Colin Dion's work, there are reflections on law, how law governs and regulates life and death of the unfamiliar by rendering it familiar into categories of governable, an activity that is more in the interest of efficiency than of justice. Both Dion and Karan Moran speaks of dehumanized spaces, such as prisons and slaughterhouses, the use of shared spatial metaphors consciously melded into each other to demonstrate how fluid they are and subjected to similar violence, conveying the force of law very effectively. The next three headings are a broad type of cases that I've seemed to have noticed. It's just initial venturing of jurisdictions, so exploration of jurisdictions. So the first set of cases is judicial helplessness to deal with the question of animal legal personhood. The first case most of you might be familiar with, the Tommy and Kiko chimpanzee litigation that non-human rights project in the US led. The chimpanzees were kept in the zoo and then they were sought to be transferred to a sanctuary. That was the claim made in the petition. The judge couldn't grant it, no matter how sympathetic he was to the cause of chimpanzees suffering in closed enclosure, no matter how much freedom the sanctuary offered. The second one is the funny case of the monkey selfie, the Indonesian macaque which took the camera of David Slater and took the picture, and Peter then sued him because, well, the copyright belonged to the monkey. The judge was very happy to listen to all the arguments. Indeed, he was very sympathetic to the labor of monkey, but he said, well, he sincerely believed that their upbringing in the positivistic tradition will not let them think outside of their box. They fear toppling of precedents and cannot begin to think what is it to set a precedent. Second one is judicial reluctance, mostly for obscure and unstated reasons. Justice versus Gwendolyn Washer is the 2017 Court of Appeals case where a horse rescued by an animal defense fund from its previous owner who was abusing it, and the horse was really emaciated, and the suit was brought in the name of the horse, which is justice. Very ironic name. And it sought compensation from its previous owner for the abuse suffered. The judge said, okay, you're just wasting judicial time because I don't want to listen to this uncharted policy area. And he even specified one single line in the judgment which runs into 2 pages, where he said if you can appeal this decision, and if the appellate court is very fond of moving into the field of policy and recognizing animals as legal person, they can do it, but I will not, in no uncertain terms. Peter was Germany didn't involve any animals. The suit was not brought in the name of any animals, but they had advertised animal holocaust on your platter. And they used holocaust reference to refer to slaughter of animals. And in Germany, the ad was sought to be banned. They appealed and went into the European Court of Human Rights, and the judges were very categorical in the fact that animal suffering is not the same as human suffering, and they are really violating the integrity of the victims of actual Holocaust by referring animal holocaust and trivializing human suffering into the level of animal suffering. A lot of internal contradictions, unsupported reasoning, but well, there we are. The third category is judicial overreach, and the 3 cases that I can bring up are all from India because we are known for judicial overreach. And it's a pain to read this judgment, so I decided to keep these from the paper I had written because it's easier to speak about them than write about them. And every time Indian courts do something, everyone is fond of citing it, hailing it, but however palatable they may be, they have actually no constitutional or statutory basis. So the first case runs into 2 pages, and the Delhi High Court decided to arbitrarily extend Article 21 of Indian Constitution to all birds, reading dignity of life, not specifying whether the court understood non-human dignity of life any different from human framing of it. The preamble of Constitution of India reckons that it's a document written and given to themselves exclusively by and for the people of India. Subsequent to the judgment, there were quite a few laughs about how Indians will from now on miss their favorite delicacies involving chicken. Nothing much came of it, nor any more judicial time invested on the question. The birds continued to be caged and killed, drawing no benefit from an illusory constitutional protection. The second one, the Nagaraja case, is a little more important, and they did invest some thought in it. It was a case dealing with the legality of Jallikattu, a form of bull taming festivals that had deep historic and cultural significance to the people in southern India. The practice was challenged on grounds of animal cruelty, and the court too upheld the challenge and banned Jallikattu on grounds that animals had constitutional rights, right to live with dignity and enjoy a life free of cruelty. Well read into Article 21. There were state-specific amendments to Prevention of Cruelty to Animals Act subsequent to this judgment, and following which the matter was referred to higher bench, and it remains inconclusive even today. There were more discussions on damages to cultural rights of the people in this case, and by the way, cultural rights of people never find a mention in Constitution of India. They seem to have taken that liberty to talk to it. Then the possibility of extending constitutional rights to animals, as the court had done. At this stage, we can only hope that eventually some bench in the apex courts returns to this important constitutional movement and lays down the groundwork for moral constitutionalism. And while this is a kind of a parody judgment to the previous one, for 2 reasons. The question, the non-human rights was absolutely not the question before the court. But in any case, that didn't stop them from expending 60 pages on this matter. The question was whether horse-drawn carts should be allowed between India and Nepal for toll reasons, tax reasons, and someone vaguely mentioned that the horses were injured in the process, and the court just went on all ballistic about non-human rights. And second, the court in this case also dramatically named all the citizens of the state as in loco parentis, that is, guardians of all animal life in the state. It's ironic because the previous year the same court had upheld the culling policy of the state. They always have this regular culling of vermins which are all destructive to crops, and they said, well, killing doesn't matter if the state sanctions it. That's all was the reasoning. But the only paragraph which drew my attention was the analogy of foreign citizens and extension of rights to them. The court seems to have followed the reasoning that non-human life is foreign to our community, and hence there is a basic minimum protection that needs to be extended, just as it has done to those human beings outside of territorial and legislative boundaries. But the question is, are they foreign to our moral and juridical boundaries? The animal question will always turn its back to the law, like Jambo does here. I do not know what the photographer Tim Flack intended when he posed the chimpanzee in this way, but it seems to embody the entire animal legal personhood litigation in this image. And if you read the quote from Povinelli, where she is speaking in the context of indigenous environmental litigation, it becomes so obvious that indigenous justice is in absolute solidarity here on this question. The law lacks metabolism to digest what animals are seeking, and that is precisely the injustice we need to address by converging multiple worldviews in juridical spaces. We are no longer working our ways through legitimacy and strength of Christopher Stone's argument, not that should trees have standing. We are now at the edge of a moral precipice. We are in the Anthropocene, and that brings with it new pressures and also new consciousness, both legal and moral. The argument here is law, as Nicholas Luhmann says, is an autopoietic system, means it holds immense possibility of new forms of litigation and legal ideologies. It is not so much a politics of legal personhood as much as it is the politics of justice and perhaps injustice. The necessity of redesigning justice for all environmental litigation in the Anthropocene. It calls for radical environmental jurisprudence outside of courts, in policy, governance, and legislation. Pinning our hopes in the juridical may fetter this discourse of animal legal personhood in matrices of precedents. While we make concerted efforts to give courts a touch of nature, there is need to recognize our kinship and articulate it in compelling ways that make it difficult for the courts to decide otherwise. We need to decenter law from legal personhood, and that's going to be the new hallmark of environmental and animal rights litigation in these times. Thank you.